Hey everyone, this is Mike DeBliss. This is a continuation of the podcast series on the Fourth Amendment. We're now up to searches conducted pursuant to a warrant. To be reasonable under the Fourth Amendment, most searches must be pursuant to a warrant. Basically, the warrant requirement serves as a check against unfettered police discretion. It does that by requiring the police to apply to a neutral magistrate for permission to conduct the search. Now, this doesn't mean that a search conducted without a warrant will always be invalid. There are circumstances where a search without a warrant is valid, and there is basically 6 categories of permissible warrantless searches that we'll get to in the next podcast. But for now, let's stick to this topic of searches conducted pursuant to a warrant. So, what are the requirements for a warrant? To be valid, a warrant must first be issued by a neutral and detached magistrate. Second, it has to be based on probable cause, established from facts submitted to the magistrate by a government agent upon oath or affirmation. And third, it must particularly describe the place to be searched and the items to be seized. So these are the core requirements. And again, they are going to be the requirements that we focus on in this podcast, and that will continue to be the theme throughout. They must be issued by a neutral and detached magistrate. The second requirement is that the warrant must be based on probable cause. And third, the warrant must particularly describe the place to be searched and the items to be seized. Let's talk a little bit about the showing of probable cause. A warrant will be issued only if there's probable cause to believe that seizable evidence will be found on the premises or person to be searched. The officers that request the warrant must submit to the magistrate what's called an affidavit. And this affidavit has to contain sufficient facts that will enable the magistrate to make an independent evaluation of probable cause. The officers cannot merely present their conclusions that probable cause exists. Again, it's a very specific requirement. The affidavit must contain sufficient facts that enable the magistrate to make an independent evaluation of probable cause. Now, in many cases, the affidavit contains information that is provided to law enforcement by informers. And so what I want to talk about right now is the use of informers when the affidavit relies on information that's provided by them. If the officer's affidavit of probable cause is based on information obtained from informers, the test for whether it's sufficient is determined by the totality of the circumstances. This is sometimes referred to as the totality of circumstances test. Now, the affidavit doesn't have to contain any particular fact about the informer, so long as it includes enough information to allow the magistrate to make a common sense evaluation of probable cause. Essentially, that the information is trustworthy. So, at one time, it was required that the affidavit include information regarding the reliability and credibility of the informer and her basis of the knowledge. These are still relevant factors, however, they are no longer prerequisites. And basically, what I'm referring to here when I talk about reliability and credibility of the informer, essentially an example might be that the informer has given information 5 times in the past and has been accurate. And when it comes to basis for the knowledge, an example might be that he or she purchased cocaine from the house to be searched. Once again, these are still relevant factors, but no longer prerequisites. How about the informer's identity? Generally, the informer's identity need not be revealed to obtain a search warrant. However, if the informer is a material witness to the crime, her identity may have to be revealed at or before trial. Now, when a defendant attacks the validity of a search warrant, the Fourth Amendment safeguards come into play, and they permit the defendant to contest the validity of the assertions in the affidavit upon which the warrant was issued. The defendant is allowed to go behind the face of the affidavit. There are three primary requirements to invalidate a search warrant. It's not easy, I should start out by saying. It is quite challenging because if you think about it from this perspective, a judge, or rather a magistrate, has already reviewed an affidavit that was prepared by law enforcement and has already made a finding regarding that affidavit. Finding, of course, that it was reasonable under the circumstances. So when an attorney later on in the process challenges the sufficiency of the warrant, the second judge that's reviewing it is basically reviewing the findings that were made by the magistrate. So the idea here is that an official, the magistrate, has already reviewed and found the affidavit to be sufficient, and so it's already at one level at least past constitutional muster, and that's why it's very difficult to invalidate a search warrant when you're later on in the process and the search has already been conducted and evidence has been seized. But nonetheless, a search warrant issued on the basis of an affidavit that on its face sufficiently establishes probable cause will be invalid only if the defendant establishes all three of the following. First, that there was a false statement included in the affidavit by the affiant. Typically, the affiant is the police officer that's applying for the warrant. Second, that the affiant intentionally or recklessly included that false statement. And when we talk about intentionally or recklessly, these are legal terms of art. Essentially, the officer must have known it was false or included it knowing that there was a substantial risk that it was false. And finally, the false statement must be material to the finding of probable cause. And basically, without the false statement, the remainder of the affidavit could not support a finding of probable cause. So the mere fact that an affiant intentionally included a false statement in the affidavit apparently will not automatically render the warrant invalid. So I'm going to list these requirements again because all of them have to be met in order for the search warrant to be found invalid. First, a false statement must have been included in the affidavit by the affiant. Second, the affiant must have intentionally or recklessly included that false statement. Third, the false statement must be material to the finding of probable cause, meaning that but for the false statement, the remainder of the affidavit could not support a finding of probable cause. And these requirements come from the U.S. Supreme Court case of Franks versus Delaware. Now, evidence may be admissible even though the warrant is not supported by probable cause. So here's what I mean. A finding that the warrant is invalid because it was not supported by probable cause will not entitle the defendant to exclude or suppress the evidence obtained under the warrant. Evidence obtained by police in reasonable reliance on a facially valid warrant may be used by the prosecution despite an ultimate finding that the warrant was not supported by probable cause. And what we're really talking about here are technical defects in the warrant. these technical defects are an insufficient basis for overturning the warrant, the magistrate's decision that the warrant was sufficient. All right, so I'm going to just go over that again because it's a mouthful. A finding that the warrant is invalid because it was not supported by probable cause does not automatically entitle the defendant to exclude the evidence obtained under that warrant. And the standard here, once again, is that if the evidence obtained by the police was obtained in reasonable reliance on a warrant that was not supported by probable cause, it may still be the evidence may still be used by the prosecution. Again, even though the warrant was not supported by probable cause. The standard is whether the police acted in reasonable reliance. Now, the warrant must be precise on its face. And what we mean by precise is that it must describe with reasonable precision the place to be searched and the items to be seized. If it doesn't, the warrant is unconstitutional, even if the underlying affidavit gives the detail. So here are basically two hypotheticals that we can work our way through. In the first hypothetical, the warrant authorizes the search of a premises located at 416 Oak Street for heroin. Now, 416 Oak Street is a duplex, and the issue here is whether the warrant is sufficiently precise. In this case, it wouldn't be sufficiently precise. Why? Because 416 Oak Street is a multi-unit dwelling, so the warrant must specify which unit is to be searched. But I say that with this caveat. If the police, and this gets back to the reasonable reliance standard that we just talked about, if the police reasonably believe that there's only one apartment on the floor of a building, the warrant is not invalid if they discover during the course of the search that there are in fact two apartments on the floor. Any evidence that the police seize from the wrong apartment prior to the discovery of the error will be admissible. Again, this is getting back to the reasonable reliance requirement. In our second hypothetical, we have Allen, who police believe to have committed criminal fraud in regard to certain complex land transactions. A search warrant is issued authorizing the police to search for and seize numerous documents and other fruit instrumentalities and evidence of the crime at this time unknown. Is the warrant sufficiently precise? Yes. Why? Well, given the complex nature of criminal fraud and the difficulty of predicting precisely what form the evidence of guilt would take, under these circumstances, the warrant is sufficiently precise. So as you can tell here, the crime itself is a factor. And because criminal fraud, because there are so many different type forms of evidence that criminal fraud could take that could provide a roadmap to the fraud, and the complex nature of this crime, that in itself allows the police some leeway in being a little vague in general in describing what they're looking for in the search warrant. So again, in this case, the search warrant basically described what the police were looking for as other fruit instrumentalities and evidence of the crime at this time unknown. And again, given the complex nature of the crime and the difficulty of predicting precisely what form the evidence of guilt would take, the court in this case basically found that the warrant was sufficiently precise. Now I want to talk a little bit about the search of third-party premises. the Fourth Amendment does not, and I repeat, it does not bar searches of premises belonging to people that are not suspected of a crime, so long as there's probable cause to believe evidence of someone's guilt will be found. Again, the Fourth Amendment does not bar searches of premises belonging to persons not suspected of a crime, so long as there's probable cause to believe evidence of someone's guilt or something else subject to seizure will be found. So what that means is that a warrant can be issued for the search of the offices of a newspaper if there's probable cause to believe evidence of someone's guilt of an offense will be found. And that was a Supreme Court case decided in 1978 called Zurcher versus Stanford Daily. Now, the neutral and detached magistrate requirements. This issue has was previously litigated, but now no longer is really an issue when it comes to testing the validity of a warrant. But nonetheless, it does provide some historical perspective. The magistrate who issues the warrant has to be neutral and detached from what we might consider the competitive business of law enforcement. So here are some examples. A state attorney general, it seems obvious, is not neutral and detached. Believe it or not, that was litigated in the case of Coolidge versus New Hampshire, going back to 1971. In the second example, a clerk of a court may issue warrants for violations of city ordinances, but just city ordinances. In our third example, a magistrate who receives no salary other than compensation for each warrant issued is not neutral and detached. In the fourth example, a magistrate who participates in the search to determine its scope is not neutral and detached. Now, we are going to move on to execution of a warrant. And there are some requirements and protocol that must be followed by law enforcement here. And some of them are blatantly obvious, and then some of them aren't so obvious. So we're going to start from the obvious and then move to the not so obvious. First, the warrant must be executed by the police. And so private citizens, of course, may not execute a warrant. In addition, when executing a warrant in a home, the police may not be accompanied by a member of the media or any other third party unless the third party is there to aid in executing the warrant. So what I mean here when I say that there's an exception for the third party being there if they're there to aid in executing the warrant, what I mean by that is if the third party is there, for example, to identify stolen property that might be found in the home. In a case decided back in 1999, the court found that it was unreasonable to allow a newspaper reporter and photographer to accompany the police during the execution of an arrest warrant in the plaintiff's home. And the rationale there was that to be reasonable, police action pursuant to a warrant must be related to the objectives of the warrant. The court further reasoned that the presence of reporters or other third parties that are not aiding in the execution of the warrant renders the warrant unreasonable. Now, while the First Amendment prohibition against abridging freedom of the press is an important right, the court nonetheless held that it does not supersede the very important Fourth Amendment right of persons to be free of unreasonable searches. So in that case, the First Amendment prohibition against abridging freedom of the press squared off against the Fourth Amendment right of individuals to be free of unreasonable searches. And you can see here how the Supreme Court justices felt about the Fourth Amendment right of people to be free of unreasonable searches. They felt that it trumped the freedom of the press, and that is one of the reasons why the case is so notable. Now, The second requirement is that the warrant must be executed without unreasonable delay. And that's because probable cause is essentially it waxes and wanes. That's the best way, I think, to put it. And it may disappear if an unreasonable amount of time goes by without the police executing the warrant. So what I find and what I see frequently is that the search warrant typically has an expiration date, and usually it's open for a couple of days. And this, of course, it depends on the nature of the items that the police expect to find at the location. So as you can imagine, if we're dealing with drugs which are easily destroyed, which can easily be destroyed, then it could very well be that the magistrate provides a narrow window for police to execute the warrant. Same applies when it comes to weapons. But the magistrate isn't going to give the police carte blanche to take their time and, over the course of 2 months, decide which day they're going to execute the warrant. And by the way, the warrant will also provide a time, a range in hours in which the police can execute the warrant. And again, if it's a narcotics-related search warrant where the police believe that narcotics may be found in the target location, the magistrate might provide more leeway to the police by opening up the window or time frame that is that they can execute the warrant, to perhaps include early hours of the night, so as to allow the police the element of surprise and to avoid the risk that the evidence might be destroyed in the course of the execution of the warrant. There's also an announcement requirement. This is a third requirement. An officer executing a search warrant must knock and announce her authority and purpose, and then await admittance for a reasonable time or be refused admittance before resorting to force to enter the place to be searched. Now, as you can see here, the language that's being used is very vague in general. This is Supreme Court language, and the reason why it's vague in general is because the Supreme Court, that is, basically sets the ceiling, and the states can actually afford more rights than is allotted by the Supreme Court. So what the court was doing here was basically providing the bare bones requirement, and allowing the states, if they did, to afford more rights, more Fourth Amendment rights. But it starts out with this very vague requirement that the officer executing the warrant must knock and announce her authority and purpose, and then await admittance for a reasonable time or be refused admittance before using force to enter the place to be searched. Now, there's sufficiency of delay. This comes up very frequently. If the officers executing the warrant have a reasonable fear that evidence like drugs will be destroyed after they announce themselves, the court found that a limited 15 to 20 second delay before using force to enter the house is reasonable. So I'll say that again. If the officers executing a warrant have a reasonable fear that evidence like cocaine or heroin will be destroyed after they announce themselves, a limited 15 to 20 second delay before using force to enter the home is reasonable. Now, this is this of course, is a slippery slope because, there's basically nobody there to hold the police accountable. So in it's very likely that the police will not even wait the 15 to 20 seconds before using force to enter the house. And it's I've even been involved in cases where clients have said that there was no knock whatsoever, and just a battering ram, and all of a sudden a large a large noise that was heard, and then yelling and screaming to get down. So this whole issue of sufficiency of delay and the announcement requirement is it sounds very good in theory, but in practice, is it followed all the time? Well, I would guess from experience that it isn't, because again, there's nobody there that is actually counting the 15 to 20-second delay, or ensuring that these requirements are being followed. Now, there is such a thing as a no-knock entry. No announcement needs to be made if the officer has reasonable suspicion that knocking and announcing would be dangerous or futile, or that it would somehow impair the investigation, for example, because it would lead to the destruction of evidence. And a request for a no-knock entry is usually made in the affidavit, and if it isn't, then it's not a part of the warrant. But it's typical these days that when law enforcement is looking or suspects that drugs will be found at a location, for the affidavit to contain a request for a no-knock. Whether no-knock entry is justified must be made by the magistrate on a case-by-case basis. A blanket exception for warrants involving drug investigations is not permissible. So it's not automatic that if the affidavit contains suspicion or probable cause that drugs will be found at a location, that the magistrate will automatically grant a no-knock warrant. However, there are few cases that I've been involved in where I've found that the magistrate rejected that request. It's usually pretty standard that the magistrate will permit a no-knock entry whenever the officer's affidavit contains suspicion that there are going to be drugs found at the location. The fact that property damage will result from a no-knock entry does not require a different standard. So the location that the police have identified could be a Victorian mansion, and the request might be for a no-knock entry. The fact that the door is a wood door in a Victorian mansion wouldn't change the standard. There's reasonable suspicion is sufficient, and property damage doesn't come into play. The fourth requirement, seizure of unspecified property. When executing a warrant, the police may generally seize any contraband or fruits or instrumentalities of crime that they discover, regardless of whether they were specified in the warrant. So if while executing the warrant, the police come upon a gun, for example, and there was no mention of a gun in the affidavit that provided probable cause for the warrant, the fact that the police found or noticed the gun in plain view when they were executing the search gives them grounds to seize it. So it's very important that you understand that it's not limited. The search is not limited to what's contained in the four corners of the search warrant, and that things found in plain view that are considered the fruits or instrumentalities of crime can be seized. Fifth requirement is search of persons found on the premises. A search warrant does not give the police carte blanche to search people found on the premises who are not named in the warrant. If the police have probable cause to arrest a person discovered on the premises that's being searched, they then may search that person incident to arrest. Okay, but that's under the standard of search incident to arrest. Again, the search warrant does not unilaterally give the police carte blanche to search anybody found on the premises who are not named in the warrant. If the police have probable cause to arrest a person discovered on the premises, for example, if they come upon a person inside the home that they have a search warrant to search, smoking cocaine or marijuana, and thus violating the law, they can then arrest that person because they have probable cause to arrest that person, and then they can search that person incident to arrest. Detention of occupants. A warrant to search for contraband that is founded on probable cause implicitly carries with it a limited authority to detain occupants of the premises while a proper search is conducted. And the theory here is that what the police are trying to do is to make sure that there's no danger presented to them during the course of the search, and that the occupants are not still in the premises while they're conducting the search, so as to destroy the fruits or instrumentalities of the crime, like drugs. So the occupants can be detained, and oftentimes are detained, either outside of the home or perhaps in an open area inside the home while the search is being conducted. Usually what the police do is they before they even begin searching, they go through the house, and they look in all the rooms as well as closets and any other crawl spaces to make sure that they clear the premises of any individuals, and that they have isolated everybody that's inside the house, and then they begin the search. And they do this under the grounds of police safety and prohibiting the destruction of evidence as they search the home. So this concludes the podcast on searches conducted pursuant to a warrant. In the next podcast, we'll move on to exceptions to the warrant requirement.